And this is Ken Kraetzer at the PACE, Professional Association for Customer Engagement seminar here, the Washington Summit in Washington, D.C. I have a chance to talk with one of the speakers, and that is Lauri Mazzuchetti, who is an attorney based, did you say New Jersey?
I'm at Kelley Dryer and Warren in the New Jersey office.
That's great. Well, you led a session today that spoke about the impact of the recent Federal Communications Commission ruling over the summer about the TCPA that affects so many aspects of contact center work and calling customers of institutions. Just tell us a little bit about the impact of the Federal Communications ruling this summer that's of so much concern.
Sure. One of the biggest impacts is on how we deal with disconnected and reassigned cell phone numbers. There's really no tools for businesses to determine when a cell phone number stops belonging to one consumer and begins belonging to another. So there was a plea to the FCC that please bring some sanity because, we think we have the consent of our customer. We're trying to reach them legitimately, and unbeknownst to us, the number changed hands. And the FCC didn't give really any glimmer for the business to hook onto to defend those claims, and said we're only going to give you a one-call safe harbor. And unfortunately, if nobody answers the phone on that one call, you're going to be liable for those calls. So that was really like the big ticket item in the FCC order. The second big ticket item was on the definition of an automated telephone dialing system. There was a little bit of a debate amongst the courts about whether it meant present capacity to dial numbers in a random and sequential way, or whether future capacity could be considered if a technology could be programmed, although not being presently used for that function, if it could be programmed for that function. And unfortunately, once again, the FCC didn't go to go with business, and they said that it can apply for future capacity, and we're going to leave it up to the courts to decide on a case-by-case basis, what constitutes an ATDS and what does not.
Okay, and your panel really highlighted what the impact of this could be in terms of class action suits and liability. Some very big numbers mentioned at risk for practitioners and marketers, and those just trying to serve existing customers. Why is the risk from class action so severe from this ruling?
Well, because typically when a claim is brought, the plaintiffs are attacking all of the calls, all of the text messages that a company is sending. So they have one class representative that received, some number of calls or text messages, and now they're going to try to bring in all of the calls over a certain time period, or all of the text messages, whether it be on a certain campaign or a certain type of call. So you can very quickly get in the hundreds of thousands or even millions of calls, and at $500 per call or text message, the numbers can get very, very big, very, very quickly. It's very rare that you get a case where you're dealing with 10 text messages are at issue. Typically, we're in the thousands, and we're talking to clients about numbers that are in the hundreds of millions or even the billions of dollars when you do the straight math.
And is there a key aspect of advice that you could offer to practitioners, to marketers? I mean, we work with some of the largest banks in the country, and we know there's a lot of concern. Is there a key advice? Is it just record keeping that's so important?
What I tell clients is you don't dabble in telemarketing or outbound dialing, text messaging. You really need to get good counsel and to make sure that you're complying not only with the federal laws but also the state laws. So you really need some good advice. You need to watch the changes in the laws and hire either a good compliance organization or lawyers to navigate you through that process.
Absolutely, and if you would just tell us a little bit about your law firm and maybe a little bit about your career.
Sure. So I have been at Kelley Dryer for about 15 years, and I would say that over the last 7, my practice has predominantly focused on defending these types of claims, TCPA claims or government-instituted actions regarding telemarketing calls or outbound dialing. And we at Kelley Dryer approach the TCPA and marketing by phone, fax, text, kind of in 3 different ways. We look at it from the litigation side of the house, which is what I do. And then I'm teamed up with practitioners that specialize in the area of what the Federal Communications Commission does. So they're really on, watching the regulators from that perspective. And then The third leg of the stool is the Federal Trade Commission, which has a whole, other set of laws and regulations that apply as well.
Very good advice, and you're doing a lot in the field of telecommunications. We appreciate. Lauri Mazzuchetti, thank you. Good to see you here at the PACE Association meeting in Washington, D.C.
Thank you very much. I'm happy to be here.
Good to see you. This is Ken Kraetzer for CBSI Services in Washington, D.C.